Now we are going to see about the transfer for benefit of unborn person and also perpetuity. Section 13 deals with the transfer for benefit of unborn person. Transfer of property means transferring the rights over the property to another person. If a person is giving the rights to another person, there must be somebody to receive the rights. What is giving should be received by somebody. But an unborn person is a person not in existence. What to do? That is, section 13 gives a solution for that. Where on a transfer of property, section 13, where on a transfer of property, an interest therein is created for the benefit of a person not in existence at that date of transfer. That is, an interest is created in favor of a person not in existence at the date of transfer. Two conditions are given. Subject to the conditions. A prior interest is created by the same transfer. One condition. Prior interest is created. Second condition, absolute right is transferred to the unborn person. These are the two conditions. For example, we are having a box. A person is having a box, it has to be given to his son. The son is not there. He has gone somewhere, he will come after 2 hours. But this person wants to give it to him. What he can do? He can give it to his friend. This is the box, my son will come, give it to him. So what that person's duty? He has to take care of the box. He has no right over the box. It has to be given to the person's son. Same is the case here. The Act says you create prior interest. You engage somebody to keep the interest in the property and to hand over it to the person, unborn person, when he comes to the world. For example, we will take an example. One person wants to transfer the property to his grandson, but his son is not married now. What he can do, he can transfer the property to his wife for her life. At the end of the life, the property to be transferred to his son. So, son will also have the property. And at the end of the life of the son, the absolute interest in the property should go to the grandson. So, this is a chain. This wife and son have only life interest. They cannot sell the property. They don't have the absolute right over the property. They have only life interest, limited interest. Only the unborn person has a interest over that. So this is a chain. He gives to his wife, wife gives to his son, son gives to grandson. So from grandfather, the property goes to grandson. Only grandfather was having absolute right, and the same absolute right is transferred to grandson. In between these two people are prior interest people. They have a limited interest in the property. They have only life interest. So the two conditions are prior interest can be created and the absolute interest should go only to the last person, that is unborn person. Next condition is the prior interest, all the persons, the prior interest person should be in existence at the time of transfer. At the time of transfer, the prior interest people should be in existence. One condition. Another condition is the unborn person should come to the world before the last person dies. That is the same example. Grandfather wants to grandson, transfer to wife, wife to son, son to grandson. If the son dies before the grandson comes into the existence, then the cycle is over. The property will come back to the original position, original person. that is the last unborn person should come into the existence before the last person of the prior interest dies. This is a condition. He has to come into existence before the last person dies. Then the absolute interest. Only absolute interest should be transferred. That you cannot write, you enjoy the interest for your life, next to turn for his life, next to grandson to his life, and then to the next person to his life. It is not possible. The absolute right should go to the unborn person. Then only the transfer is valid. The same section, same type of section is there in section 113 of Succession Act regarding the property to be passed on to the next person there. Hindu law does not permit this, but after coming to the effect of transfer of property, it is applicable to Hindus. For Muslim law, this gift to an unborn person is not permitted, so it is not applicable. This is section 13. Now we will move on to the next one, perpetuity, that is permanently. You cannot transfer your property permanently to persons. You cannot hold it permanently. For example, the same example. The person wants to transfer property to grandson and so on. He says, you hold this property for your life to his wife, and then to my son for his life, and then to grandson for his life, and then to his son and his son, all these things. That means no one is given absolute right over the property. What will happen? The property will be tied up. If a person is holding a property, only he and his family will have right over that. Nobody will have a right to sell it. If that is the case, what will happen? For example, because of industrial development, company may require land for production activities, but there will be nobody to sell it because everybody will have only right to enjoy, only life interest. No one has a absolute interest if it is permitted. Further, if it is transferred, then only the government earns income. Otherwise, no income. So that is why this section 14 has come. It is limiting the length of the transfer. What it says, the length of the transfer shall be the last person's death plus 18 years. That is a maximum. For example, the father, that grandfather transfers to his wife. Wife was there for 30 years. After 30 years, it goes to son. Son for 30 years, 60 years over. Then maximum 18 years for the grandson. This is the maximum. That is prior interest people's last person's death plus 18 years. The section I will read. No transfer of property can operate to create an interest which has to take effect after the lifetime of one or more persons living at the time of transfer. That is after the lifetime, the minority of some person who shall be in existence. That is minority period, 18 years or 21 years if court appointed guardian is there. Maximum period is 18 years. We will see what are the things required. There should be a transfer of property. Transfer to create interest in an unborn person. The last person life plus 18 years in the case of minors or court appointed 18 years. Minority period of the unborn person. That is the maximum period. Another one, there may be interest created by one or two or three persons. In our case, what we have seen is transferring to wife, then to son. After the son's death, it is maximum 18 years. That is a period of perpetuity. That is life of the last person plus 18 years. This is a maximum. But they give a grace period also. Sometimes on the death of the last person, on the death of the son, the grandson may be in existence in mother's womb. For that 280 days gestation period is given. That is 18 years plus 280 days or 9 months is given as the maximum period. Thus 280 days is a grace period. The period of gestation is given. This is the maximum period. The person who is a minor will have only contingent interest. His interest will be absolute only on attaining the majority. Next, there are some exceptions for that. Exceptions. One is if it is for the purpose of payment of debt. You keep the property, this income from the property should be used for paying the debt, then it is possible. If it is for charitable purpose, it is possible. Creation of charge will not be affected. The section 14 will not apply if it is for a creation of charge. It will not apply for the mortgage also. If it not, it will not affect the personal agreements. For example, there is an agreement. You will be the priest of this temple, and your son and his son, all these for generations, you take care of the temple as a priest of the temple. It is permitted because it is a personal agreement. Mortgages will not be covered under that. Then covenant running with the land will also be not covered under the perpetuity rules. For example, a person selling may put a condition. In this place, you should not construct anything. This should be kept vacant. So this is a condition put by the seller to the buyer. If the buyer again sells and so many transfers, this covenant, this term, condition will be going along with the sale agreement. There is no restriction on that. The perpetuity rule will not apply for the covenant running with the land. Now we will see the next session in with another topic.